Hall and Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello and welcome back to our Doing Business in Australia podcast. My name is Mark Dunphy and I'm a partner at Hall and Wilcox. For those who live and work in different countries, it's essential to understand the issues involved in cross-border succession planning and the area of international wealth. To delve deeper into these issues, I'm delighted to be joined by my colleagues and fellow partners Emma Woolley and James Wiley, who are specialists in this area. Welcome to you both. So Emma, perhaps can we start by setting the scene? Why is this a particular issue in Australia?
Thanks, Mark. Well, like me, 49% of Australians are either born overseas or have a parent who was born overseas. So very many people in Australia will have some connection to another jurisdiction. And those international connections create complexity because when we retain either assets or family in other jurisdictions, we necessarily retain connections to other systems of law, which can make planning really difficult. And sometimes even hard to determine exactly how to structure affairs during people's lifetimes, and that complication continues after they're no longer with us. So many people do not make a plan or are unaware that they really need to make a plan. And the other issue is quite a lot of people balk at the complexity and the cost of having to take advice in multiple jurisdictions. So some people will take the sort of they'll never know approach, and that's particularly common in our experience when we're dealing with people who have US and UK connections or citizenship.
Great. James, where you have someone with assets both in Australia and outside of Australia having the connections that Emma describes, what advice do you give to someone? Where do they need to start?
Yes, Mark. So first steps are always to really understand the details of the assets and connections. There are a range of questions which really need to be considered. The key is clearly that you need to make sure you're asking the right questions. But firstly, you need to make sure that you've got details of what assets the client has outside of Australia. It's easy when you have someone with an accent like Emma or me, and this flags that you have those connections to overseas jurisdictions. But if not, it's really important to ask, do you have assets outside of Australia? Have you lived outside of Australia? Are you a citizen of another country? It's only when you have this information to hand that you're ready to determine the impact and then work out what advice we need to give. It's important that advice is really taken in the right places and the right time.
So once you get that picture and have an understanding of what jurisdictions are involved, what's next?
Well, Mark, once you've got the lay of the land as far as the assets go, and this includes understanding whether the people you're dealing with have existing structures like trusts in this jurisdiction or others, then we've got to work through what is it that they want to happen when they're no longer with us. And then it's our job to work out what's the best way and what the best documentation will be to give effect to those wishes. And as I mentioned before, some clients are really reluctant to take advice in all relevant jurisdictions because they're concerned that we're overcomplicating matters or over cost issues. Certainly, most people would say that having one single will to deal with everything would be the simplest approach, but having one will per jurisdiction can make things a lot simpler after a person dies. A saving they were not necessarily going to appreciate because then they're no longer with us. Having one will in each jurisdiction can allow for the administration of an estate to run in parallel, so you can choose also local executors to deal with things in each jurisdiction. The other thing to consider is we've got to think about the formalities to make sure that a will's valid. We have to make sure that we get that right in each jurisdiction where the will's going to need to be used. So the will has to be valid where the assets are or has to be valid in the jurisdiction which is relevant. So getting local advice will be really important to avoid that will being ineffective. Some countries which are signatories to certain conventions, which includes quite a number of EU countries, but not actually the UK, which never signed up to that particular convention even before it left the EU, that convention and those countries allow their residents to elect so they can choose which system of law will apply to their will. And some countries like Australia and the US and Italy are signatories to another convention which allow citizens or residents of those countries to prepare a form of will which is known as an international will, which will be recognised in every signatory country if it's signed in accordance with the requirements under that convention. So there's lots of things to consider when you have assets in multiple jurisdictions. Is one will the right way to go? Is it necessary to have multiple wills? What are the requirements in each jurisdiction? And do any of these conventions apply? One point to think about when we're making multiple wills in different jurisdictions is to make sure that they all line up and they don't inadvertently revoke each other and end up with a situation where we don't have a valid will for whatever reason. So lots to think about when you have different jurisdictions in play, Mark.
Indeed. I expect you'll also have to think about where the people, the clients, want to be involved in key decisions or benefit from the estate or resident.
Yes, that's definitely a key issue that needs to be considered, Mark. Very often we have people who want to, say, appoint a child overseas, for example, to be in the UK to be their executor. Is that an issue? And generally recommend that practically people do pick someone locally if possible because of the geography and because it's often better placed for them to attend to matters like signing contracts or having to sell real estate in Australia. Aside from the practicalities of having a foreign executor, it also has potential tax consequences. Like many aspects of trust and estate law, tax can influence the mechanics of things. For tax purposes, an estate is treated as a trust, and this could create an issue from an Australian tax perspective. Residents of your executor could make the residents of the estate non-resident and be treated as a foreign trust, but it seems the tax office doesn't always take that position. However, the question of who the executor is and where they are is still important. It may be, for example, appropriate to appoint someone in the UK, but also allow for someone in Australia to be their co-executor, an alternative, to ensure that the estate is Australian tax resident. That means, for example, you can ensure that the 50% CGT deduction can apply to the sale of investment properties.
Yeah, that's right, James. And dying in Australia is one of the very few things that you can do without incurring any tax, usually. Australia allows for the deferral of tax by way of a rollover of any capital gains which might arise on the death of a person under legislation in Australia. A capital gains tax asset can pass from a deceased person to their executors and on into the hands of the beneficiaries without a liability arising. The executor or the beneficiary inherits the cost base of that deceased person, and any pre-CGT assets get a step up in value. But there is a difference when, like here, we have a non-resident beneficiary. So taking James's example where we've got an overseas daughter in the UK, we have lots of clients who are in a very similar position and they want to benefit people who are not resident in Australia or no longer resident in Australia, like a child who's moved away and settled outside of Australia in the UK. We need to be really careful here. As I mentioned, there's a difference in the way that Australia taxes people who are not resident. Gifts of assets pursuant to people's wills, which are not taxable Australian property, and that's defined under the legislation. And taxable Australian property includes things like direct interest in real property and indirect interest in real property. But assets which are not taxed will be taxed in the hands of the beneficiary when they're not resident in Australia. And the estate is responsible for meeting those tax obligations before any other assets can be distributed. So everybody in that estate is going to be impacted by the decision of the executor to distribute or the decision of the deceased person to leave assets to people who live outside the jurisdiction, because everybody's going to have to pay the tax. Now, they might not think that's particularly fair, and so they might not be particularly delighted that they have to bear the burden of a sibling's tax residence when they live overseas. Or they might think it's just unfair that they have to pay the tax at all. There are some options that can be put in place to manage that. It'd be good if the executors have some flexibility about whether or not to give overseas beneficiaries TAP assets or not. And so generally to have flexibility about how they distribute the estate. One other possible way to manage this is to include provision in the will for the executors to be able to attribute the tax liability to the share of the person who's non-resident. So rather than everybody having to bear the burden of the tax, just the person who's non-resident will be able to bear that burden. So there's a few things that could be done, but it's not to say that there isn't some complication arising.
So, Emma, we don't have inheritance tax in Australia, but is this an issue to consider where people have connections to or assets in other countries?
Yep, that's right. As I said, we're one of the very few jurisdictions in the world with no direct death tax. Jersey, where I'm from originally, is another place. And I think there are at least 15 OECD countries that have a tax. The US and the UK are countries many people will be aware of having inheritance tax, but they don't actually have the very highest rates. In fact, the highest rate of inheritance tax globally is Japan, which sits at 55%. And then South Korea is next, with the UK and the US in equal fourth. As I said already, it's really important to understand how the laws of other countries operate so we can make sure that there's no surprises when it comes to tax. In the jurisdictions where tax is determined on the basis of where the assets are. So we need to understand and focus on the residence and sometimes domicile of a person in determining whether there's any tax burden that might flow as the result of the death. If we don't get this advice, so if clients won't look at this in detail or won't allow us to assist in managing this, then the result is that we could miss out on opportunities to actually manage this tax. There are things that can be done to mitigate or manage the impost of inheritance tax in other jurisdictions. Taking the US as an example, the US is all about citizenship. It's very hard to get US citizenship and it's very expensive to give it up in certain circumstances. And if you're a US citizen, you're taxed for life on your worldwide assets, and you're also taxed on your death on your worldwide assets. So when you die, if you're a US citizen, it doesn't matter where your assets are, they will be potentially subject to the US inheritance tax regime. There's currently a very high threshold in the US before that tax is actually imposed. At the moment, it's about $13.5 million US dollars. So this is a tax that really only impacts 1% of the US population or 1% of global US citizens. So it's not really a very impactful tax, but there has been indications given in different sides of politics in the US to say that they're looking to adjust that threshold, perhaps to adjust it down, and other sides of politics have indicated that they might do away with it entirely. But the reality is it is in existence at the moment, and there are potential for big changes to happen, but it's not really clear about the timing of when those changes will occur. So it's really important that US citizens who are subject to the potential US inheritance tax take advice about what arrangements could be made to manage that. Non-US citizens can also be impacted by US inheritance tax. If anybody holds assets over the value of 60,000 US dollars, then they will be subject to tax on those assets at a rate of 40%. There is the possibility to get some sort of treaty relief because we have a tax treaty with the US, Australia. And so there is also the possibility to get some relief if you do hold those assets. But the only way, if you're a US citizen and you want to get out of the US inheritance tax regime, is to give up that US citizen, so expatriate, which for some people, Mark, is really not very palatable. So there's lots of planning opportunities to manage or defer the tax, but unless you take advice in that jurisdiction and unless we put the plan together, they're not going to know.
Thanks, Emma. Is it the same in the UK? Do UK citizens have the same issues in relation to their assets here, or is it a different regime that applies in the UK?
Yes, Mark. So the UK can impose inheritance tax to UK citizens, even if they have moved to Australia permanently, or to Australian citizens who have the UK as their permanent home or have assets in the UK. It's slightly different. The UK looks at this concept of domicile as opposed to citizenship. But what's worse than the US is the UK imposes inheritance tax at 40% on the individual's worldwide estate above what's called their nil rate band, but that's only £325,000. And although you've got the ability to port that to your spouse, you've effectively got 650. It affects far more people than the US, much higher threshold that Emma spoke about. Transfers between spouses are fortunately exempt, but that's only if you're married and only if you're the same domicile status. So, for example, if you've got someone who's moved here from the UK and met someone in Australia, they're potentially of different domicile statuses, and you might not get that exemption. What can also capture people unaware is that, for example, here, their accountant might suggest to set up an Australian trust for tax planning. It's very common that people have trusts here. But if you're dealing with someone who's from the UK and still UK domiciled, transferring those assets into the trust can be hit by a 20% inheritance tax charge above that £325,000, along with 10-year anniversary and exit charges. Mentioned before, the UK currently imposes an inheritance tax according to what's called your domicile status rather than citizenship or residency, but there's no single definition of domicile, so it's quite difficult sometimes to determine. You're born with what's called a domicile of origin, and archaically that follows your father if your parents were married at the time of your birth, but you can acquire what's called a domicile of choice. In Australia, it's actually state-based. So for someone like myself who's moved to New South Wales permanently indefinitely, acquired at what's called a domicile of choice here. What the difference is, so if the individual still has retained their UK domicile, then they're subject to inheritance tax on the worldwide estate. However, if they've acquired a domicile of choice and the HMRC equivalent of the ATO in the UK accepts that, you're only subject to inheritance tax on your UK assets, not what you have in Australia. So currently, one thing we do for clients is often recommend that they prepare what's called a statutory declaration of domicile, of evidence of their domicile status here, that domicile of choice, and that can be used as a formal legal evidence if it's ever challenged. However, following the recent UK budget early this year, it's anticipated that it's going to be a dramatic change to inheritance tax. And they're proposing to abolish this very old concept of domicile in favour of a residence-based system. Under the new rules, it's proposed that the UK will impose inheritance tax according to an individual's resident status. So if they've been a UK resident for 10 tax years, they're going to get caught by inheritance tax on their worldwide estate. But if you leave the UK, you've then got this 10-year tail whereby you're still subject to inheritance tax there. So whilst these new rules do provide for more certainty because the residence-based test is clearer than domicile, it does mean that people, for example, who've moved here and are going to be caught for a longer period than the current rules, which either impose a 3 or a 5-year tail, depending on the circumstances. It's very hard to advise on this as well currently because whilst the UK government has given a date of 2025 for the changes, the consultation hasn't begun to commence, and you'll probably have seen that there's going to be a UK election in July, and it's anticipated there's going to be a change of government. So watch this space.
Great. The key then seems to be, James, to getting advice at the right time to ensure that the plans that people have take into account all those potential complications.
Yes, that's definitely right, Mark. Most people we look after have at least one connection, whether that be being born overseas, like myself or Emma, holding assets or business interests outside of Australia, or having family resident overseas. That could be a simple rite of passage, children of a client going to spend time living overseas, either temporarily and perhaps meeting someone there, and the impacts that Emma spoke about then, about gives to them. As a result of this, we developed an excellent network of advisors in other jurisdictions, and this enables us to put together an effective one-stop shop, drawing upon those connections to assist in putting together a comprehensive plan.
Great. At a domestic level, we've been speaking about international obligations, but at a domestic level, we've spoken about there being no inheritance tax regime in Australia. With federal government and most state governments having significant debts, I just wanted to ask about whether there's is it on the radar and what the scope of the or policy of the various parties might be with regard to that.
Thanks, Mark. That's an interesting question, and it certainly does come up occasionally at the times of state or federal elections, discussion around whether or not this would be introduced. I'd say that it would be an entirely unpalatable tax to take to the voting public. A tax on death is not an attractive thing at all, and it's generally something that people would vote against, I'd suggest. In Australia, we don't have a direct inheritance tax, but we do have some taxes which arise on death. So, for example, in the superannuation space domestically, when a person dies, superannuation has to come out of the super fund. Death is what's known as a cashing event. And in certain circumstances, depending on who receives the benefit of those superannuation death benefits, there could be tax payable at that point. So there is tax triggered by death in certain circumstances. And given that there are literal trillions of dollars sitting in superannuation, it's quite the opportunity for the federal government to reline its coffers on the death of tax-paying super holders. As far as an actual direct inheritance tax, I think there hasn't been anybody that's attempted to put together policy around that. But again, like the UK, there's significant changes there, and we never know. We'll just watch this space, Mark.
I'd have thought perhaps it might be more palatable if they brought it in at that high level, like the US, for example, because it impacts far lesser people than the very low, threshold in the UK that impacts lots of people there. It's just really impacting the super wealthy there as a perceived thing. We did used to have it in Australia, but it was used to be state-based, and they got rid of it after Queensland got rid of it and all the rich retirees moved there. I think it'll have to be a federal measure if they do decide that, to avoid a similar thing these days, other than obviously moving to Queensland for the weather.
Thanks, James and Emma. Thank you particularly for those discussions on the domestic situation, and particularly the observations that you made about cross-border succession planning and the areas of international wealth. I want to thank everybody for listening to today's episode of this podcast. If you have any questions, please feel free to get in touch with us. You can find our details on our website, or you can connect with any of us on LinkedIn. If you enjoyed today's episode, please rate, review, and follow our podcast wherever you listen to podcasts. Many thanks.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.